The first case is In Re Reliability Plans. We'll start with the appellants. I understand there will be shared argument, and I'll let you guys explain what you're doing with that, if that's okay.
May it please the court. Spencer Sattler, Assistant Attorney General, appearing on behalf of the Public Service Commission. With me at council table this morning is Deputy Solicitor General Eric Restucia and Deputy General Counsel of Consumers Energy, Kelly Hall. I will be dividing my time evenly this morning with Ms. Hall, and I would like to reserve 3 minutes for rebuttal. At stake in this proceeding is the Public Service Commission's ability to ensure that there is enough local, long-term capacity in Michigan to serve the state's electric needs. Section 6W gives the state, or gives the commission, this authority by creating what the legislature called a state reliability mechanism that requires electric providers, including alternative electric suppliers, to show that they will have enough total and local capacity to meet demand in 4 years. I plan to focus on subsection 8. That's at the heart of the state reliability mechanism, while Ms. Hall will focus in on subsection 6 and why it does not free alternative electric suppliers from their local clearing requirement. Before I get to subsection 8, though, it makes sense to start with subsection 2, where the legislature directed the commission to establish the state reliability mechanism as provided under subsection 8. And this takes us to subsection 8B, where the legislature imposed the individual obligation on suppliers by requiring them to demonstrate, and I'm paraphrasing here, that they own or have contractual rights to enough capacity to meet their capacity obligations in 4 years. If not, their customers will end up paying a capacity charge and another supplier will provide the capacity. Subsection 8 describes the two components of this capacity obligation. There is the local clearing requirement, which, as the name suggests, ensures that there's enough local capacity to meet long-term demand. And there's the planning reserve margin requirement, which is designed to ensure that there's enough total capacity, including external resources, to meet peak demand, plus an extra cushion that the legislature called the planning reserve margin, and that's commonly called the planning reserve margin. So subsection 8C requires the commission to set both of these requirements. And there are two components for a reason. If either piece is missing, it jeopardizes the purpose of section 6W, which is to ensure reliability. And that's because it's possible for every electric provider in the state to have enough total capacity, counting external resources, to meet long-term demand, and still not have enough local capacity to meet long-term demand, which could result in blackouts or brownouts. And that's because suppliers can rely on market resources to meet their total capacity needs.
Council, how do you respond to the argument that they're posing that this reduces competition and will ultimately make it more expensive for providers?
There certainly could be an impact on the price that alternative electric suppliers are paying for capacity, because right now they are primarily relying on external resources that are cheaper than resources within the zone. And so there will potentially be an impact on price, but it's really necessary to ensure reliability, because like I was saying, if there's not enough local resources in the zone, it jeopardizes reliability because there are infrastructure limits on the amount of capacity that can come from outside of the state. And to ensure that there's enough local capacity after accounting for these infrastructural limits, the legislature created the local clearing requirement to promote reliability and ensure that providers aren't over-relying on resources that are coming from outside of the state. Because if they over-rely on resources coming from outside of the state and there's not enough transmission capability to import those resources, then we have a reliability problem. That's why the legislature created these two components, because without both pieces, it's impossible to ensure the reliability of the transmission system. Act 341 gives them this authority. And ABATE and Energy Michigan have argued that the Commission's local clearing requirement isn't consistent with federal reliability requirements. Now we have MISO on the record in this case in an amicus brief saying that the two requirements are consistent because it's possible to simultaneously comply with each requirement without running afoul of the other. And if any organization's opinion should be given weight on this subject, it's MISO's, because MISO is not only the organization that set the zonal local clearing requirement that's been the subject of so much hype in this proceeding, it was also tasked by the Michigan legislature with helping the Commission set its local clearing requirement. And if the legislature saw fit to show MISO this much respect in Act 341, this court should also seriously consider MISO's opinion in interpreting Act 341.
Counsel, can I ask you a threshold, at least what I view as a threshold question? In your judgment, to what extent should the MPSC prevail here because its construction of a statute within its jurisdiction is entitled to respectful consideration according to our decision in Rovas? And to what extent should it prevail because our understanding of the plain language of the statute should prevail? In other words, if there were no deference owed to the agency at all, would you still be arguing in favor of the MPSC's position here?
Absolutely, Your Honor. I think that the plain language, when reading subsections 8B and 8C together, support the Commission's position, regardless of the amount of deference afforded. However, the amount of deference afforded is important in this case because it is a complex statute. There's no question about that. And under In re Rovas, this court is to afford respectful consideration to the Commission's decisions and not overturn them without cogent reasons. And in fact, in the Youngkin decision, I'm not sure I'm pronouncing that correctly, but in that decision, this court held that as long as the Commission's statutory interpretation is consistent with the legislative intent as expressed in the plain language, it should not be overturned. And in fact, there are no cogent reasons to overturn it. And in this case, we certainly have an interpretation that's consistent with the plain language, and there are no cogent reasons to overturn it.
Further, if the standard this court applied in giving meaning to the statute was its traditional standard, which involves inquiring what the reasonable meaning of words and terms and language are, if that was to replace this standard that seems to have been adopted in this context, inquiring whether the language is clear and unmistakable in some regard, would that tend to facilitate your position or hinder your position? In other words, replacing that clear and unmistakable language standard by what in most other contexts is simply the obligation of this court to give reasonable meaning to the language of the law.
I think that the Commission's position is the right position under either standard. And whether or not the replacing the clear and unmistakable standard with a more general standard, if I understand you correctly, requiring that the court give the language its natural and reasonable interpretation. Replacing the clear and unmistakable language wouldn't really change the outcome in this case because there is clear and unmistakable language, and it's also, and the Commission's interpretation is also a reasonable interpretation of the language.
So by saying it wouldn't change the outcome, you're basically rejecting the idea that the Court of Appeals, in relying fairly unquestioningly upon the clear and unmistakable language standard, didn't draw the conclusions it did as a function of that standard. Is that fair to say, too?
Yes, I think that's fair. And I'm not sure that the Court of Appeals completely respected the interplay between subsections 8B and C, because again, in subsection 8B, the legislature was imposing the individual obligation on alternative electric suppliers to demonstrate that they'll have sufficient capacity to meet their capacity obligations in 4 years. And then subsection 8C describes the capacity obligations referred to in subsection 8B as including two components, the local component and the total component. And that really that language is at the heart of the state reliability mechanism. I see that I'm eating into co-counsel's time, or rather Ms. Hall's time. And
Swap fast. Yeah.
Good morning, Your Honors. Chief Justice McCormick. Kelly Hall on behalf of Consumers Energy Company. I'm addressing the exception that the appellees contend excuses alternative electric suppliers from being required to comply with the local clearing requirement component of capacity obligations under the state reliability mechanism. Contrary to the appellee's arguments, subsection 6 does not accuse alternative electric suppliers from complying with the local clearing requirement as other electric providers, as defined in the statute, must meet. Contrary to the appellee's arguments and the Court of Appeals decision, the exception afforded in subsection 6 applies to when an alternative electric supplier can demonstrate that it can meet its capacity obligations through owned and contracted rights to any resource that MISO allows to meet the capacity obligations of that provider. MISO does not have a resource construct that allows a provider to meet its state reliability capacity obligations. The MISO construct, as articulated by MISO in its briefing in this proceeding, is separate from the capacity construct under the state reliability mechanism. At the time Act 341 was enacted, there was pending a proposal at the Federal Energy Regulatory Commission, which included a number of means by which a provider could have met forward capacity obligations. They included a capacity forward auction as well as a prevailing state compensation mechanism. I would note that the existing MISO planning resource auction, which is a residual one-year auction, does not fit within the definition of a capacity forward auction in Act 341, subpart 6W12. That MISO proposal for a forward capacity construct by which a provider could meet forward capacity obligations was rejected by FERC after Act 341 was enacted. And there exists today only a short-term resource adequacy construct at MISO that only applies for the current planning year and is, although complementary, it is different and distinct from the state reliability construct that the Michigan legislature enacted. I would call your attention also to the provisions in subpart 8, subpart C and D that call for the Michigan Public Service Commission to consult with MISO for technical assistance and to ensure that the capacity obligations set by the Public Service Commission are consistent with federal resource adequacy requirements. In subpart C, the legislature called the Public Service Commission to determine capacity obligations. Similarly, in that the exception relied upon by the appellees in this matter, in subpart 6, it refers to capacity obligations. The capacity obligations under the state reliability mechanism include two components as articulated by Mr. Sattler: the planning reserve margin requirement and a local clearing requirement. And to satisfy the state's four-year forward capacity obligations, each electric provider has to meet both components. But the MISO requirements remain as federal reliability requirements, but they are not a capacity obligation as used by the legislature in subpart 8C, as well as the exception in subpart 6, which refers to capacity obligations. It does not refer to federal reliability requirements, except for the requirement that the capacity obligations have to be consistent with federal reliability requirements. Implementing a local clearing requirement on individual electric providers, including alternative electric suppliers, does not conflict with MISO's federal resource adequacy requirements. MISO has stated affirmatively so in its amicus brief filed in this proceeding. MISO further stated that its reliability requirements are designed to meet separate but complementary goals to the state. I would note that MISO does not allow out-of-zone resources to qualify that for the local clearing requirement, even in its one-year construct, and the Commission is acting consistently. Thank you.
Thank you, Council.
Good morning, may it please the court. Mike Patwell on behalf of intervener appellee ABATE, which is to be distinguished from the motorcycle group ABATE. The ABATE before the court today is the Association of Large, mostly industrial customers of electricity. Today I'll be splitting my time with co-counsel Brian Doyle from Energy Michigan, which leaves me 10 minutes. ABATE would urge the court to deny the applications for leave to appeal of the Michigan Public Service Commission and Consumers Energy for reason that the Court of Appeals correctly determined, using a plain reading, that Section 6W of our new energy law does not grant the Public Service Commission the authority to impose a locational requirement on individual electric suppliers. At the outset, I'd like to emphasize that the question of whether 6W of our new energy law grants this power is a question of major economic and political significance. And that point has been explained through the numerous amici briefs that were filed showing how thousands of schools, hospitals, business, and other customers save millions of dollars by purchasing their energy from alternative electric suppliers on the choice market. And the choice market was created by our Customer Choice Act, which was specifically designed to allow alternative electric suppliers and their customers to access external resources outside of the state of Michigan and to access MISO's federal power markets. Restricting access to those resources has dramatic ramifications. One, because alternative electric suppliers rely on those resources, and two, because the incumbent utilities own virtually all of the local capacity in the state of Michigan. The legislature understood these policy considerations when it was deliberating over the 2016 energy package, and that is exactly why in the final amendment to that legislation, two important changes were made. First and foremost, the final amendment to the bill removed express language that granted the Commission authority to impose a locational requirement on alternative electric suppliers. It removed the grant of power out of the legislation. It also added Section 6W, which authorizes alternative electric suppliers and alternative electric suppliers only, it's an AES-specific provision, to use external resources to meet their capacity obligations. This case is not about capacity obligations. It's not about the question of how much capacity a provider needs.
Council, the reason why we normally don't try and read legislative history tea leaves is because we can get it so wrong. And why isn't the Michigan Chamber correct that the reason why the specific percentage on the local clearing requirement was removed was because of Hughes and the Supreme Court cases trying to manage the balance of power between state regulators and federal regulators and not wanting this statute to get thrown out of court in a federal court? Why isn't the Michigan Chamber right about why that was removed? And maybe why shouldn't we therefore just talk about the statute, because there's at least two competing reasons why it might have happened, and this is why we don't read legislative tea leaves.
Sure. So first, the argument is that by removing an express grant of authority from the act, that the legislature actually intended to maximize the Commission's authority to do just that, to the outer bounds of federal preemption law, that is actually not what the amendment did. The amendment did not just remove a specific dictate to the commission of what percentage the commission should impose. It removed the totality of the grant of authority.
Well, I don't know what you, well, okay, then let's just go to the statute. So the statute, you agree, it seems like the Court of Appeals says that the statute allows or requires the commission to determine capacities, individual capacities of every kind of supplier, utilities, alternatives, rurals, cooperatives. It also requires each provider to meet its capacities. So why would we read 8B and 8C together to say that the commission can't do anything about what it has determined and the fact that each supplier has to meet it? Why then can the commission require any supplier to meet a local clearing requirement or even to meet the planning reserve? I mean, why isn't the same logic applicable to every single thing the commission is supposed to do under this statute?
Sure. Section 8C is a generic provision, and it speaks to how the local clearing requirement and the planning reserve margin requirement are calculated. And if we look at the definitions in the statute of those terms and the common understanding of the terms under the MISO, those are zonal concepts. This is a zonal provision that doesn't.
Well, so now you're moving to the second argument. So you might be saying, the Court of Appeals said two things. One is the statute needed to, I guess, specifically say, even though it requires each provider to meet its capacities and it requires the commission to determine its capacities, it doesn't say you can impose the capacities. It sounds like you want to focus more on what it means to determine the individual capacities, and it means zonally and not individually. Is that right?
Yeah, in a real
I'm
basic,
happy to talk about that.
in a real basic sense, MISO has a construct where MISO determines capacity obligations and it sets a local clearing requirement, but we know that it doesn't impose the local clearing requirement on individual alternative electric suppliers. The same is true here. The commission's argument and reading of the statute is entirely inference-based. There is no grant of authority that specifically authorizes the commission to take this very drastic action of major economic and political significance to impose a locational requirement that prohibits alternative electric suppliers from doing what the Choice Act was designed to do and buy power from outside of the state of Michigan.
Help me understand the difference between what MISO does and what the commission believes it's supposed to do in terms of the local clearing. My understanding is MISO is regulating the wholesale market across a region that includes both peninsulas as well as many other states. Am I right so far?
Right.
Yeah, and making sure that in a 1-year process, because power is unlike any other commodity, you can't store it. It has to, supply and demand have to meet, exactly in the marketplace. That it has to manage throughout the MISO region, that wholesale market, right? And then what the state has to do is manage reliability just within the state. So why isn't the MISO zone and the state of Michigan apples and oranges or apples and grapes?
I see that I've greatly exceeded my time and I've cut it into.
I thought you said you had 10 minutes, no? But you can defer if you want.
But I was still going to attempt to answer the question. I think there were a lot of parts there, but the key difference between our resource adequacy construct under the statute and MISO's is that MISO's construct applies in the prompt year. And Michigan's applies 4 years out. And if I'm understanding the question is, why would the statute authorize the commission to set or determine a local clearing requirement if it couldn't be reasonably inferred that that local clearing requirement had to be imposed on individual suppliers? And the way that we've read and the Court of Appeals read the statutory section there is that that function is informative. And why is it informative? Because it makes perfect sense, just like MISO, that our commission would set the LCR, even though it's not going to impose it on alternative electric suppliers, because it's setting it 4 years in advance. It's not setting it for the current planning year. That would allow the commission to know 4 years forward whether Michigan is scheduled to have enough local resources. And alternative electric suppliers are very different than incumbent utilities. They compete in a 10% market. There are 26 of them. The utilities have a monopoly and a regulatory compact with the people of the state of Michigan where they don't have any competition. They're guaranteed that business. And consequently, the entire statutory regime grants us more regulatory authority over the commission, in particular, the authority to decide whether or not their certificates of needs to build new generation can be issued, guaranteeing payment and a 10% return on equity to the utility, whether or not existing resources that have already been paid for by the ratepayers can be terminated early, and the list goes on and on and on. So there is meaning in setting but not imposing, and when we look textually, there still has to be an inference by reading that statutory language, and the existing precedent is very clear that you can't extend inferences, and silence in a statute does not grant an administrative agency a power. And I think if I could say one last thing, that's particularly important here where the power is an awesome one and the power was incredibly controversial and has significant economic and political ramifications. Now that I've correctly viewed the time, I see that now I am over my time and I will digress. And I just want to say this is an honor. Thank you very much.
Thank you very much.
Good morning, and may it please the court. Brian Doyle on behalf of ABATE Energy Michigan. If we take a step back from the acronyms, the regulatory background and framework, what this application involves is the commission's claim that it can tell alternative energy suppliers, energy companies, if you want to do business in the state of Michigan, if you want to sell your energy in the state of Michigan, you have to buy your capacity in the state of Michigan. And that's a remarkable claim of power and authority.
Well, wait a minute. It says you have to buy a certain percentage, right? And according to the first rundown in 2023, you might have to buy 1.7% of your power in Michigan. 98% you can buy outside of Michigan. But there might be a point in 2033 where the local input is such that to make sure Michigan's grid doesn't fail, which would have catastrophic effects for all businesses in Michigan, we might have to change that number a little bit, and we're giving the commission some capacity to make sure that in 2033, if we have a local input problem, we're a peninsula, it's weird, it's hard to get power in and out of Michigan, they have to be able to manage that, right?
The pithy response is a little bit illegal is still illegal, a little bit unauthorized is still unauthorized. But I think the more important response is they're not asking for any limitation on their authority. They're asking for the authority to manipulate, control the market and to tell out-of-state, in many cases, entities, you want to do business here, we're going to tell you how much, up to 100%, that you have to buy here. And importantly, and I think this is key, the commission admits in its application that the statute is silent on that point. The statute, they admit on page 47 of their application.
If we look at the silence of the statute, and I appreciate your argument, but shouldn't we kind of infer that the entire perspective of the PSC is to keep the power grid safe and usable for Michigan residents?
Under the, we're on a well-worn path. Every 10 years, the commission, we're on a schedule under Union Carbide, Consumers Power, 1988, 1999, and now today, where the commission says we have a broad grant of authority under a statute. There are dire economic and policy concerns that justify our broad grant of authority, and this court steps in and rationally says, no, your authority must be clear and unmistakable. It's not clear and unmistakable, and that is the test. Policy, economic concerns really play no role in the de novo statutory interpretation that this court applies.
What language in the statute gives them therefore the ability to impose the planning reserve margin? I don't see any difference in I see that they get to set it, the local capacity, and I see that the energy providers have to meet it, but why, if you're right, can they do anything? Why don't we just rip the statute up?
Well, the statute defines clear concepts and defines them separately. Of course, the commission has the authority to impose a capacity obligation, which is separate from a local clearing requirement. What the commission, what appellants do is they attempt to conflate local clearing requirement as part of a capacity obligation. That's the only way their argument works. Of course, they have the authority to impose on each supplier a capacity obligation. Have you contracted or do you own enough energy to meet your customers' needs? That's capacity obligation. Local clearing requirement is something completely different. That is, how much energy does the entire zone need? What's the minimum that MISO is going to tell the commission that the entire zone needs? It's a zonal definition in the statute. If the legislature intended...
But MISO's managing wholesale markets across a zone, so it needs to make sure that Zone 2 doesn't have to suck from Zone 7 or Zone whatever, because that would crash the grid. And Michigan, on the other hand, has to manage the retail reliability and distribution of power, right? And likewise, if your region is just Michigan, it wants to make sure we have the local power within our grid not to crash, not for the Lower Peninsula or the Upper Peninsula to crash it. So why wouldn't they both be necessary to ensure long-term reliability? And why isn't that what the legislature wanted?
That's what the legislature wanted. That's what's happened for the past 2 years. For the past 2 years, a zonal local clearing requirement has been applied. It has not been applied individually. It's been applied zonally as it's defined in the statute as a zonal tool. At the same time, each supplier has been assessed their own capacity obligation. So over the course of the past 2 years, that is exactly what's happened. The LCR has not been imposed individually. It's been imposed on the zone. Does the zone have enough energy? What does MISO tell us about how much energy?
What does it mean to impose it on the zone if it doesn't? Like, explain how that works. I know it's not an issue until maybe 10 or 15 years out, but say we think the zonal number is 10 and it comes back 9, then what?
The market controls that. If there's not enough energy in the zone, the price of the auction price for energy increases on all suppliers. So the market regulates itself in that respect. But to answer your question, both can work. A zonal requirement on the zone not applied to any individual supplier, and a separate capacity obligation. It's key that those are viewed as they're defined as separate and not conflated into one requirement, as
I have
appellants would urge.
questions, so I'm going to make sure if other people have questions, we're going to keep you up for a minute because I'm sorry. Do you have questions?
Yeah, can I ask
Please.
a follow-up question to what I asked of the Attorney General's initial counsel on argument? I asked him about whether there were any significant differences between the traditional approach to jurisprudence, giving meaning to the law that this court applies, and the particularities of the clear and unmistakable standard that's applicable in this case. This court, in the course of interpreting the law, this court every day gives some meaning and consequence to what I'll call pregnant silences, the absence of language, reasonable inferences, logical assumptions, implicit language. Your view, is it not, is that some or many or maybe all of these approaches to giving meaning to the law have to be curtailed somewhat as a function of this clear and unmistakable standard? I ask you that, just as I asked the opposing counsel, only because it seems to me to be a significant issue involved in giving meaning to the language of the very complex statutes involved in this case. Am I understanding you correctly?
You do understand our position correctly. It's a position that goes back to Union Carbide, Consumers Power, and it's the correct standard that the Court of Appeals followed. That when the question of statutory interpretation
and maybe
involves,
that influenced its result as well. Is that fair to say?
I'm sorry, Justice.
And the Court of Appeals' application of the clear and unmistakable standard was arguably a significant contributing factor to the result reached in its decision.
It was, although when the language just isn't there, it doesn't matter what standard you use. The Commission admits there is no language that gives them the authority to dictate the market. That language is absent. The statute is silent on that. And so I think, yes, clear and unmistakable is the correct standard, but when the language was removed, when the language isn't there, you're going to do pretty well under any standard of review in that case.
Are these two standards in conflict? In other words, can't we read the statute in a reasonable way and give context to the words, and then take that interpretation and ask the question of consumers' power? That is, if there's going to be a grant of authority to the Public Service Commission, it must be clear and unmistakable. Are these two things in conflict?
I don't view them as being in conflict, no.
Okay.
Yeah.
Further questions from the court? Thank you very much, counsel.
Thank you, Justices.
Thank you.
Is there any time left?
Oh, you had no time left. I'm sorry. The case will be submitted. I was supposed to say that. Yeah. Case will be submitted. Thank you.